Yes. Call the list, please.
Item number 1.
Happy?
May I have your seat, please?
Yes.
My Lord, on the last occasion, well, they argued basically 2 points. One is that there is 54, there is no prohibition in clause 54 of the contract. But later on they say that they are not pressing for that. But still then, my Lord, on the last occasion I have shown to my Lord that so far clause 54 is concerned, my Lord, there is a prohibition of interest, my Lord, and my Lord, your Lordship, my Lord, I have shown one of the decisions of the Supreme Court of 2009 inside Ahmad's case, my Lord. So not to that extent, my Lord, that is there. Now, my Lord, I just want to impress upon my Lord that say there is a prohibition.
Let us see 54 again. Let us see 54 again.
446 again, 446. 446 volume 2, my Lord. Page 446, volume 2, my Lord. Judgment निकालना My Lord got it, no? May I read?
Yes.
No claim for interest or damages will be entertained by the corporation with respect to any money or balance which may be lying with the corporation owing to any dispute, differences or misunderstanding between the individual in charge on the one hand and contractor on the other, or with respect to any delay on the part of the engineer in charge making periodical or final payment, or in any other respect whatsoever. Now, this particular clause, as it is.
Now please come to the award.
My Lord.
Page
501 of the same volume, my Lord. Now the concluding part of the award your Lordship would like to see. But so far the interest is concerned, my Lord will find that part has been dealt in page 525.
You see, the award is like this. Item number 2.
My Lord.
Payment towards reimbursement on account of
Escalation in
minimum wages.
yes.
Then pre-suit interest. This is not something which is lying in your account. Which may be lying with the corporation. It is not lying with you. You have to make payment.
Yes, my Lord.
So this interest bar clause will not apply. Now come to the next. Payment towards reimbursement of 10% of contract's profit. So much.
This was line, Lord. Payment towards adjustment deductions.
Yes. Payment towards unjust deduction towards reinforcement of
Refund of amount deducted.
that may be payment, that may be money in your hand,
And
but not item number 4, 5. Only 2.
reimbursement of contractor's profit, then claim of account of ideal overhead charges from May Samsung. What I am trying to say, that this particular exactly same clause 54 has been dealt with the Supreme Court in Saeed Ahmad case. Saeed Ahmad Company versus State of Uttar Pradesh and others.
Yes.
In 2009, 12 SCC 26, your Lordship will find in the judgment compilation at page 1. My Lord, may I take my Lord to directly page paragraph 7, page 5. Page 5 of my Lord, the regular page, my Lord. The judgments page is page 30. Now, may I read? Interest from the date of cause of action to the date of award, para 6, para 7. The issue regarding interest as noticed above revolves around clause G1.09 of the technical provision forming part of the contract extracted below. Now, this particular clause is not exactly the same which clause 54 in our contract. May I read, my Lord?
Yes.
No claim or interest or damages will be entertained by the government with respect to any money or balance which may be lying with the government or any become due owing to any dispute, differences or misunderstanding between the engineer in charge on one hand, the contractor on the other hand, or with respect to any delay on the part of the engineer in charge in making periodical or final payment or any other aspect whatsoever. And if your Lordship kindly just compare, I have given a comparison also to my Lord on the last occasion.
Yes, you have cited it also.
Yes, yes.
Paragraph 14 and 19.
Yes, yes, my Lord. Yes.
And also a case of Susaka, 2019, 17 SEC.
Now, my Lord, I am left with their argument to my Lord that my Lord, there is a waiver on our part. Since we have not pleaded this matter before the arbitrary tribunal, my Lord, and we are not entitled.
2017, not 19.
2017, volume?
Volume 1, volume 12, SCR 450.
Susaka.
No, Susaka is 2018.
My Lord, I think in Supreme STC, my Lord, it is 2018, my Lord.
Handed over a copy of SCR citation.
Oh, acha.
That is why.
No, the copy here is SCC, which you have provided.
Which you have provided to us.
This is the copy.
I have provided us with
Anyway,
But just to clarify, 2017.
2007,
2017, 12 SCR
901.
My Lord?
901.
No, my Lord, 2017, volume 12, SCR 430. Should I hand over fresh copies, my Lord?
No, 1 minute.
आपका कॉपी है सर। सर ये वाला आपका कॉपी।
मेरा कॉपी।
You had cited this plus 2012, 12 SCC page 10.
Yes.
Yes, my lord, that Tehri Hydro Projects
Yes.
Development Corporation. So another
18
decision,
and 19. And you had also cited 2019,
Jayaprakash Association.
17 SCC,
Yes, my lord.
786.
786, did see, and another one, my lord, I have cited
2022.
2020, 2022, 9 SCC 286, my lord. Delhi Airport Metro Express Private Limited.
2022.
Yes, my lord.
9 SCC.
It's not in the compilation.
It's no.
No, not separately, my lord. It was separately given to my lord. It was not in the, my lord, paper. Oh, yeah. This decision, my lord, I will again place before my lord, while arguing on the my lord, waivers, question of waiver.
Yes.
Now, my lord, so far the first point is concerned, my lord, I did not go further, my lord, from this paragraph 19 of my lord Sahih's case. It's clear that, my lord, that exactly that clause is here. My lord, it says that, my lord, there is a prohibition. So, my lord, that prohibition, and my learned friend on the other day also said that, my lord, the prohibition is there, prohibition is there. Yeah.
Yes.
Now, my lord, they have argued that there is a waiver because, my lord, this clause 54.
We have noted Susaka.
Yes.
In 2017, 12 SCR perhaps.
Yes.
430.
Yes.
Yes.
Now that waiver and, my lord, so far Susaka is concerned, my submission would be, first of all, your lordship will kindly consider clause 54. Well, my humble submission, the waiver comes on that day when this agreement was executed and clause 54 was incorporated in the contract itself, my lord. Waiver will not come at the time, my lord, when the pleadings are made. Lord, in my humble submission, that will be that as a plea not taken. That cannot be taken in the, Lord, the SLP in the Supreme Court and all that, because, my lord, that is basically Susaka's judgment. My lord, I'll refer to that again. My submission will be that waiver by the parties not to take or not to claim interest is by virtue of clause 54 that has incorporated in the contract agreement itself, my lord. And by virtue of that, they should not have, my lord, made a prayer, or they should not have made a claim before the arbitrator itself that they are entitled to claim in view of clause 54 itself. Secondly, my lord, they have argued that we have not raised the point or not taken the plea before the arbitrated tribunal that clause 54 applies, and as such there is a provision they are not entitled to.
No, you tell us this, that how can waiver be made concurrently with formation of a contract? It has to be at a later point of time.
No, what I'm trying to say, my lord, that is,
You can't enter into a contract and at the same time waive it.
my lord,
The section giving a right to claim pendent right to interest is a substantive right.
This is right, my lord.
Unless otherwise agreed.
Agreed.
All right. Let us say it is agreed that no interest is payable.
True, my lord. True, my lord.
Plus 54.
Yes.
Now at the same time you cannot waive it. Enter into an agreement and waive it. Waiver has to be at a later time. The rights and obligations under the agreement I am waiving.
No, my lord, what I'm trying to say, my lord. I'm sorry if I have not been able
You
to.
can't enter into the contract and at the same time suspend it. So waiver has to be at a later point of time. The question is whether there is waiver. Unless otherwise agreed. Yes, it is agreed.
Yeah.
That no interest is payable and you are supported by so and so judgments of the Supreme Court. Now the question is, has there been a waiver?
We will go back to previous.
Whether on the part of my lord,
Your part.
my lord, in my humble submission, not my lord. What I'm trying to say, my lord, from the pleadings itself, those 54 has not been very specifically stated. My lord, I am very clear on that, my lord, that section 54 has not been clearly stated in the my lord pleadings, in the claim, defense claim, in the statement of defense. But my lord, on certain occasions, even in some of the paragraphs which have been shown, saying that it is contrary to the contract or there is a prohibition in the contract as a whole. And those paragraphs, if need be, I can show. Even they have argued that in section 11 you have not raised this point. Even in section 11 I am not required to, but still there I will show from the materials on record that we have raised claim and only four disputes were referred to the arbitrator only. If your lordship kindly come to, well, I am drawing your lordship's attention to page 489 of volume 2. Not 489. I'm sorry, it starts from 485. 485. It starts from 485, my lord. This is the first petition under section 11. There were two applications under section 11. One in 2005 and one is in 2012. Volume 2, page 485 it starts. I'll take directly to my lord to page 488, my lord will kindly come. Page 488, my lord, last 5 lines, my lord. Clause 4, that during the execution, my lord, your lordship got it, my lord. During the execution of the aforesaid work, serious disputes arose between the parties in connection with the following matters. Now, my lord, your lordship find that dispute regarding unjust deductions towards reinforcement steel, dispute regarding reimbursement of minimum wages, dispute regarding claim of idle overhead charges. These are already the claims which has been decided. Dispute regarding the claim for reduction in the value of the work besides the disputes, namely, next my lord will find whether the claimant contractor is entitled to get interest for the pre-reference period. Next, whether the claimant contractor is entitled to get interest penalite, and whether the claimant contractor is entitled to get post-award interest and entitled to the cost of the arbitration. Now, my lord will next page 490. Clause 7. That as stated earlier, that the claimant contractor requested to send as many as 4 major disputes to the appointed arbitrator, but the respondent contractor has referred 3 disputes to the learned arbitrator. Now this is I am showing that basically there were 4. The earlier A, B, C, D. Then last part, 3 lines. 4A has not yet been referred from the conduct. It is clear that respondent contractor has adopted directive procedure to cause further loss. Remember, your lordship can skip over. Agreement was there. Then my reply to that, उसमें extra volume है. My reply, my friend has given the 3rd volume also. So for the Nippo's reply is in the 3rd volume. Extra volume that has been given. My lord will find at page 1. Your lordship can is paragraph 4, page 2, that the petitioner in this petition under section 11 of the Arbitration and Conciliation Act 1996 has paid for 2 reliefs. One relief is for appointment of second arbitrator, and another relief is for referring of 4 major disputes to the arbitrator with a direction to enter into arbitration proceeding. Now, in the context, then again, in page 4, subparagraph 5 of 7, paragraph 4 of paragraph 7, down below, that with reference to para 5(4) of the arbitration petition, I humbly state that petitioner raised 4 points claiming his disputes in para A, B, C, 4A, B, C, D of the arbitration petition. Out of these, respondent found the points raised at para 4B, 4C, D are undecided disputes and therefore referred them for arbitration. The points raised in para 4A was rejected by the NIPCO. It cannot be termed as the existing dispute as per provisions of the contract. Contract agreement, the claim of the petitioner that it is entitled to get cheap rose plus interest, etc., is not correct and has denied. So now we have denied so far their claim of interest and other things. Then page 6, para 7, that with reference to para 5(7) of the arbitration petition, I humbly state that respondent found that there are 3 disputes worth sending for arbitration, therefore sent 3 disputes. Other points raised in the dispute were rejected after consideration of the same in terms of the contract agreement. Here we say that since 3 disputes were, they agreed they were sent for arbitration. In page 6, other points raised and as disputes were rejected after consideration of the same in terms of the contract agreement. So we refer to the contract agreement and say that those disputes cannot be decided. Then,
which subparagraph you are reading?
para 6, page 6, subpara 7. That with reference to para 5(7) of the arbitration petition, I humbly state that respondent found that there are 3 disputes worth sending for arbitration, and therefore sent 3 disputes. That is what I have referred at B, C, and D. Other points raised as dispute was rejected after consideration of the same in terms of the contract agreement. Then, my lord, this was there, my lord. We have not stated anything about 54, my lord, that's true. Now, my lord, so far the order is concerned on this arbitration petition, under section 11, was of 14/9/2025, the lordship will find in volume 2, page 495. Volume 2, page 495, my lord. May I read, my lord? Well, I am not reading the entire. If your lordship kindly turn to page 496 itself, only that few portions I'll just print out to my lord. There is a provision in clause 70 of the agreement. I have got it, madam. Sorry. For referring all disputes touching upon the execution of the work in order to the question to the arbitrator, in which one arbitrator is to be appointed by each of the parties. It further appears that in course of execution of the aforesaid work, serious disputes have cropped up between the parties concerning the following matters. These are the four matters: unjust deduction, reimbursement, then claim of overhead charges, and the dispute regarding claim of reduction of the value of the work. Now, my lord, if your lordship kindly turn to next page 497, my lord, it should be in the middle, line about 11th line. Appointed Justice S.H. Chadda, High Court, so and so and so. This is said, it may also be noticed that respondents by their letter dated 17/10/2000 refer the disputes concerning the claim of for overhead charges, and again by letter dated refer the dispute concerning reimbursement of minimum wages and reduction of the value of the work. These three disputes we have referred, my lord. The respondents, however, refuse to refer the disputes on unjust deductions to the enforcement district for the arbitration. Then, my lord, your lordship can skip over to page 498. In the middle also, it will be line about, my lord, 11th. Mr. T.K. Day, like counsel for the petitioner in the course of hearing, has decided not to press before this court for directing the respondents to refer the disputes concerning unjust deduction towards reinforcement is still to the arbitrator, but reserves his right to agitate this point before the arbitrator. It is, however, contended by the learned counsel for the petitioner that even though the arbitrator has been appointed by both the parties as early in 2003, the proceeding has not at all been commenced due to the directive practice adopted by the respondents. It must be pointed out that the arbitration mechanism has been introduced by the legislature and alternative dispute redressal from the speedy disposal of the disputes between the litigants and to the minimized litigation normal. This laudable scope should not be lost sight of by the parties on the facts and circumstances of the case. No serious question of fact or law survives for consideration of this court, but a direction is called for the ends of justice. So whatever may not the disputes were referred, but in the result this application is disposed with a direction that arbitrator already appointed by the parties shall now commence the arbitration proceeding in accordance with law without further delay and within a period of 3 months. So, three matters were referred to the arbitrator. And ultimately, by this order, we will say that since already arbitrators have been appointed, they should proceed with this matter. Now, somehow the matter did not proceed, a lot of things happened. Then, you also will find there is another order. It is 352 of volume 2. May I just check? Volume 2 है ना क्या है?
वो ऑर्डर तो हम लोग
नहीं उसमें क्या 1 में है क्या? देखो सॉरी 1 में क्या हुआ है?
नहीं, ये तो कमर्शियल केस का है।
सेकंड ऑर्डर एक बार देखिए तो मेरे को ओह अच्छा I'm sorry, my lord, that order is not there. I'm just providing to my lord.
Which page is the award?
No, my lord, I'm coming, my lord. That is not there, my lord. That is there in our another volume, my lord. Not before your lordship. Oh, award. Awarded page 500. Well, before that, if your lordship kindly look, इनको दिया. The order dated 31/1/2012. They have gone for second time, my lord. They came for the honorable court for the second time
Under section.
for the Agartala bench. Copy of the petitions are not available, nor the reply, but the order is available. May I just take your lordship to the order. So the last part will be important, after hearing and all that, accordingly, as agreed by the learned counsel for the party, Justice J.K. Mehra is appointed as the sole arbitrator for deciding the following disputes. These are the 4 disputes that has to be decided. So, look, this is the position so far section 11 petition is concerned. Only 4 disputes will ultimately referred to. Earlier it was 3 minutes, in the 4th one was added. Earlier we have agreed, and earlier this in 2005 order your lordship filed the reflections there. It is there. Now, so far our defense, statement of defense is concerned, my lord will find, my lord, their claim petition, vis-a-vis our statement of defense I will show. My lord, your lordship will find the claim petition volume 2.
Yes.
My lord, will kindly directly come to page 26, volume 2. So I'm just saying only about the interest part.
Yes.
Page 24, claim number 1, but they have given up the claim number 1, they have given up ultimately. The claim number 1, I can skip over. Page 24, the claim number 1. I can skip over on claim number 1, I can come directly to claim number 2. Claim number 2, claim for reimbursement of expenditure on account of increase in minimum wages. Then pre-suit interest on amount of reimbursement. Now, readings I have नहीं है. So, look, page 26.
के बाद 31
आएगा 26 minutes they have pointed out this claim heading pre-suit interest on amount of reimbursement. Then my lord will find they have made certain statements with regard to how they are entitled to minimum wages and all that, but nothing is there about their claim of interest. But your lordship will find at page 30.
Come to page 51. Pendentity interest clearly claimed.
I am showing one by one so that your lordship, there are page 51 also there is there. Page 51 is in respect of claim number 7. May if your lordship permits, the other claims I will show, my lord. Otherwise that will be left out, my lord.
You need not, because come to claim number 7, it says pendentity interest on the awarded claims.
Yes, my lord, yes.
That is all.
Page 51. Yes, madam, there is claim. The learned tribunal is required to award pending interest on award claims from the date of the learned tribunal entering into the reference. Madam, in the earlier, they have claimed without pre-suit interest. That was I'm trying to show to my lord that their claim. Their claim was only regarding that particular amount which is disputed along with the pre-suit interest. In claim 7, they have specifically stated about pending interest. Future interest we are not since not concerned in this case, and that is permissible to be granted, or we are not showing it to it. But there are page 32, page 39, page 45, 46 and page 50. There claim of pre-suit interest are there. So that, my lord, you will find.
We are only concerned with pendent interest.
No, pre-suit interest also, my lord, here. Because your lordship will kindly find that till 1940 Arbitration Act was there. There were 3 types of suits, if I correctly understood. Pre-suit interest, pendent and future interest. Now, after 31(7) was in new Arbitration Act 1996, it says that interest prior to giving the award and interest post-award. So, pre-suit interest and pendent interest will come within the purview of 31(7) 1A, Lord. Now, our reply, if your lordship kindly directly so far 7 is concerned.
Page 176.
Huh?
Page 176.
176. My lord, page 176 of volume 2, that in response to the aforesaid claim of the respondent makes no comment being the question of clause 7 except telling that as per the contract agreement the claimant is not entitled to the interest. And in any event the matter of rate of interest claimed by the claimant is highly excessive. The landed counsel for the NIPCO will however reply to the aforesaid claim at the time of hearing. So, my lord, though clause 54 was not referred to directly, but is very specifically except telling that as per the contract agreement the claimant is not entitled to the interest. So it cannot be said that we have waived our right. So far clause 54 is concerned, my lord. Lordship may definitely say, my lord, that why you have not said 54 specifically in that. True, my lord, that should have been, my lord, but still then. That point was taken.
Claim is made and
Denial.
a general denial is made in the counter. Claim not payable, interest not payable, etc., etc.
Those are there, my lord.
Now, when the matter is argued before the learned arbitrator or before the court, now interest is a matter of right that one gets under the Arbitration Act now and previously under the CPC, Section 34.
Section 34.
That is ingrained. Like if this is the award, this pendentility post interest you will get.
Even 1970, Interest Act 1978 also, my lord.
Now, if it is not even argued before the learned arbitrator that, see, this is clause 54, this is the bar, no waiver, nothing, so no interest is payable. If this argument is not made, then in the natural course, usual course, the arbitrator has granted pendentility interest. Now, what wrong he has done?
2020.
No, whether argument was made or not made,
We are not going into any question of waiver, favor, nothing. Waiver, let us assume, must be a positive, active act, etc., etc. If it is not even argued, now this right is given to a party under the law. Now, if the contrary right to deny them this interest out of contract, etc., is not even argued before the learned arbitrator, so as a matter of right, routine, he has granted interest. Now, what is the error?
No,
34 we have there.
no, 34 आएगा, 34 आएगा.
No, we have mentioned that it was argued before
My lord, in 34 applications, my lord, and the argument submitted there, my lord. My lord, since I was not there, my lord, I will not be able to say that whether there was an oral argument or not. A part of the argument they have placed.
Who is the arbitrator?
The arbitrator was Mr. J.K. Mehra. Justice J.K. Mehra was the arbitrator. My lord, arbitrator, my lord, that's what other day I said. The record of the arbitration proceeding are not here, my lord. And those will be required to look into it, my lord.
He is still there or no more?
कहाँ रहेगा ये? Records कहाँ रहेगा? तो
Records?
records will be earlier record definitely before the
Must have been placed before my lord. The written submissions are there. This point has not been argued. They're part of the.
No, claim number 7's argument is not there. You see, there are only five, argument. I have checked it, my lord, in the morning today.
Both the parties were given their respective records. Claim number 7 written submission has not been filed by you.
No, but it is also this that because of the laches or inadvertence of a learned lawyer, if a point is not argued before the learned arbitrator, how much you will get out of penalty rate interest?
The claim comes from 22 years of.
How much? Then?
22 years.
How much?
That will come to about 12 crores.
Then the government will lose 12 crores.
Not had this point been argued, we would have dealt with it now.
So why don't you agree on an arbitrator? This point will be referred.
So let it be, my lord. Let it be, my lord. A coordinate bench of this honorable court, my lord, presided by the honorable Chief Justice. Well, since the matter was not argued and all that, that was the question there also. It says that you are
You
like,
have to agree on one because otherwise we have to make a section 11 referral. We don't have the power to appoint arbitrators.
I appreciate.
I think that course will be better, my lord. They can raise this question before the arbitration. And my lord, we will file our let the matter be decided.
Instead of capitalizing on some inadvertence or laches on the part of legal personnel who should have argued the matter, and 12 crores will go out. Why don't you adjudicate it? Whether it will-
May I just point out one thing? Can I take an instruction on this point and put it before Lordship that whether the matter now at this stage can be referred? They can, your Lordship will find one of the judgment of this.
He is not agreeing. Huh?
Because 2015 the award was passed. 2002 my claim is my client.
Yes, it
almost
is.
80 years old now.
It is crystallized now. It's snowballed.
This one,
And
it has passed.
the written submission filed by them are on record. This argument is not being taken by them in the written submission also. Just to point out.
हमारा भूल में तुम्हारा है
मेरा है, आपका ये।
हमारा भूल में दिखाओ ना तुमको in one of the decision of my lord I have in the volume your Lordship is page 120 ठीक बोलते रहा
123 is ये रहा 120.
my lord in this judgment comparison volume 1 page 123
That's enough.
my lord the then Chief Justice my lord Sanjeev Banerjee and my lord Justice W. Lindo my lord it was between the my lord NIPCO the same my lord I stand formal today and my lord Patel Engineering my lord I will not take my lord to directly to the paragraph interest has been read in page 184 but I
The orders.
कौन सा पेज कौन सा है
Para 120.
हम्म
Para 120.
पहला
Orders, court orders. Our court orders.
ये आएगा पहला 119 में लौट पहला 118 page 187 dwelling 2 judgment comparison it is only for such issues that in the light of the arbitration in the present case not having decided the issue with reference to the relevant provision that was cited in each regard to the appearance that the court desists from undertaking such exercise in the limited scope available under Section 34 of the Act and the rarefied atmosphere of an appeal under Section 37 against the dismissal of a challenge to an award. Accordingly, the grant of pre-reference and penalized interest
Mr. Agarwal, is it possible to come to a settled amount?
My lord, that was not tried, my lord. That could not be settled, my lord, I think.
No, can you mediate and
I can ask my client, my lord, definitely, it's not that. But my lord, to my knowledge, my lord, it was earlier, my lord, there was an offer and all that. We made some offer, but they didn't agree to, my lord.
There is a Government of India notification which provides that the government department can settle at a particular amount. So as per that notification, we have made a proposal after we won the 34 case that the matter be settled at that amount. But they have reduced the amount to less than what we have actually already received and they're not even appealed.
is it possible now to reopen?
Well, I can talk, my lord. I just right now I can't say, my lord, no also. It will not proper on my part to say no also since it comes from my lord's side. Well, I can try or my lord, your lordship can refer the entire matter, let it be decided in the year.
No, he has to agree, otherwise,
Because in this judgment, my lord, ultimately it was referred to.
we have the jurisdiction either to set aside the award or to uphold it. We don't have any further jurisdiction to appoint another arbitrator to, perhaps the remand jurisdiction is not there.
Not remanded, my lord. It says, my lord, may I just give me 1 minute, my lord. I just read that, my lord. Because I agree with your lordship, my lord, that your lordship's jurisdiction is
Here the learned arbitrator is no more, so it cannot be remand. It has,
No, it cannot be remanded. The fresh arbitration proceeding so far the interest question is concerned. If your lordship kindly give me 1 minute, my lord.
25 years, sir. 25 years have gone by.
and after 50 years it will be 50 crores. Now for one wretched of a learned advocate who did not argue the matter, he just left it like that.
The department also did not treat this argument in their pleadings. The government department, my lord, is very well aware, are the ones who actually draft.
Accordingly, the grant of
The 12, 25, 50, 100, like that the exchequer will be drained.
Accordingly, the grant of pre-reference and penalized interest made in each of the 5 impugned arbitral award is set aside without expressing any opinion as to the efficacy of clause 55. In that case, it was clause 55, same clause, my lord. And by leaving it open to the contractor in each case to carry the claim further in accordance with law.
Which page?
Page one.
Page 187, my lord.
Of the compilation?
Yes, my lord. Judgment volume, my lord. Judgment comparison. वहाँ तो 120 में कहाँ है? I'm reading para 19, 119, my lord. Page 167.
157.
187, page 187, 187, my lord. Paragraph 119. Accordingly, grant of pre-reference and penalized interest made in each of the 5 impugned arbitral award is set aside without expressing any opinion as to the efficacy of clause 55 of volume 2, book 2. My lord, here in this contract, it was clause 55, in our clause 54, my lord. And by leaving it open to the contractor in each case to carry the claim further in accordance with law. So ultimately, my lord, a fresh, my lord, arbitration proceeding was started, constituted of कौन था देखो
Justice Amita Roy.
नहीं ये कौन था
ये wrong.
page
308.
then they my lord raise a fresh my lord reference with regard to this
Interest.
and the matter was my lord arbitrator my lord Justice A.K. Patnaik with the point Justice Amitabh Roy and Justice Kanti Kumar Gupta. In that particular case, my lord, the Honorable Judge was, my lord, appointed as arbitrator and they have decided the matter, my lord. I have given a copy which is not, my lord, here. That copy I have already published. The pursuant to this, they went to the Supreme Court. Supreme Court did not interfere into the matter, my lord. इसमें नहीं एक वर्जन है
ये अलर्ट है इसमें।
फिर देखेगा कि नहीं देखेगा क्या मालूम। कौन सा ये हमारा वॉल्यूम नहीं है, इसको हटाओ।
ये आपका है।
नहीं नहीं,
हाँ ये आपका है।
हम कहाँ गया था वो।
बहुत
The Honorable Three Arbitrators, my Lord, claimant to this so far is concerned, and my Lord, in page 299, they have decided it. So far the prohibition of clause 54, in that case it was clause 55. It page 299 in the my Lord volume, judgment volume. Referred to section 31(7)(a), unless otherwise agreed by the parties. Then in page 300, clause 55, exactly the same clause as 54 in our case, referring to Jayaprakash Associates versus Terry Hydro Development Corporation Limited. In page 302, ultimately the conclusion. The arbitral tribunal is found by the opposite CJS bench of the Honorable Supreme Court in Jayaprakash so and so, and clause 54, 5 and 55 of the condition of contract between parties in case are similarly provided in clause 50, 51 in this case of Jayaprakash, holds that no interest can be awarded to the claim either for pre-offence period or for the penalty period. If your lordship feels, my lord, then my lord, I can definitely have a word with the client. So far, whether they agree to some.
So far as mediation is concerned, we are always open.
It will be better.
Absolutely.
If not 12, settle for 6 or something and finish it up. Otherwise, it will go to the Supreme Court, and your client is 80 years old. That also has to be seen, and he will not get the fruits of.
I understand what is falling from it.
Like getting 12 crores also might affect our conscience a little bit, that because of a lapse of a lawyer, 12 crores goes out. But getting zero also will also equally affect us. When it appears that this clause does not apply to awards in the shape of damages or payments to be made. It's only deposits on account of the contractor, which will earn no interest. But somehow the Supreme Court has ruled.
Still, when the award came to be, these judgments did not exist. That time, the Harish Chandra judgment was there, which my lord said held the correct law, but now a new judgment has come, so that has
We can't say that the Supreme Court judgment is wrongly
I
decided.
understand, but I'm just.
When how much time you will take? That's it, okay?
Second program, Papa.
It's a formal meeting, so maybe it may be referred there, and we can.
Let me take first instruction, my lord, whether they will go it or not, my lord. If not, then my lord, I will inform to my lord, his lordship will decide that matter, whatever it be.
No, somebody who can take a decision, not somebody who will push note sheets. That you see, somebody who can take a decision.
Definitely.
And somebody who is not scared. Because now with the government, is so much of scare element is there. Nobody wants to take any decision.
That's a difficulty, my lord. High officials, they so don't they don't do not
From one to the other, one to the other, they will push the note.
They will refer back to us, my lord. They'll give an opinion.
This is a Meghalaya-based company.
Meghalaya.
Meghalaya-based organization.
No, my lord, it's my lord, here.
public sector.
Public sector undertaking of, my lord,
Public sector owned by the state or center?
it's a central government.
Center.
Not a state, my lord.
Owned by the Ministry, the Ministry of Power is a shareholder.
Then they will have to refer it to Delhi. Nobody here can take the decision.
That's what at least a month's time, my lord, if your lordship can grant, my lord, because or whatever your lordship will refer. Decision will be not, my lord, I will not be, I think register, head office is in Guwahati, my lord. One office is here also in Shillong, but I don't think that they will be able to take, they have to refer the matter back to this Delhi, my lord, basically.
Can I make a suggestion? We'll have it posted next week. Let them take instruction. They are ready to mediate.
No, we will say that learned counsel or advocates of record for both parties, along with their respective clients, will sit if a settlement can be arrived at and will report to the court.
The decision makers from both ends, madam, will make that one.
Yes, yes. The sole question which has fallen for consideration in this appeal is whether the appellant is entitled to pendentility interest in the award in question. The award has been upheld. By the learned first court, but only the portion with regard to pendentility interest granted by the learned arbitrator has been set aside. Paragraph. What is the date of the award?
The date of the award is 21.
देखो तो
इंडेक्स में चाहिए
यह नहीं होगा सही क्या
The award is dated blank,
I will furnish you that.
full stop. If pendentility interest is now, if grant of pendentility interest is now upheld by this court, the appellant is likely to get about rupees 12 crores.
अच्छा उसका
हाँ बहुत कट 5615
Next, the respondent corporation resists this claim. Paragraph. In our view, considering the age of the matter, the fact that the award is in favor of the appellant and only the question of pendentility interest is involved, a settled amount may be arrived at and paid to the appellant. Also, in that view of the matter, we adjourn this appeal till
First page.
April 30th. When is it? 30th.
नहीं 30 नहीं होगा नहीं होगा can it my lord if you are not inconvenient
13th May.
13th तो पॉसिबल नहीं होगा 14th of May मिलो
A long time. Why no?
13 or 14.
Eighth May, Thursday.
नहीं होंगे सर, नहीं होंगे सर, नहीं होंगे।
अब क्या करेगा हम बोलो 5th कर दो नहीं तो
5th में
let it be on 5th मिलो if not inconvenient to my lords हम नहीं आ पाएगा तुम लोग कर देना 5th of May मिलो
5th of May may not be possible. 7th, Wednesday.
नहीं रहेंगे।
तो रहेंगे नहीं तो he'll be मतलब the advocate मतलब the counsel on record he is today also out of station he will not be available here no, that's what I'm
No, let him not be available, but he can appear online also if he likes. But then let the settlement process not be held up because he is not available. It will take one minute, yes or no?
yes मिनट true हाँ
आपका डेट कर लिए ना।
Milord, your lordship will give 1 minute 7th. 9th को हो सकता है क्या नहीं
ठीक है, मैनेज कर
7th को है हाँ ठीक है
On 7th May, at the first sitting of the court.
हाँ 7th ईटानगर है
8
Please don't do this. This does not happen in the High Court. Ask your junior. This is not an arbitration.
तीनों ईटानगर है।
This is not an arbitration that you open your diary and give dates.
I say sorry Milord for on her part
She
Milord
should be used to continuous hearings.
9th
What is this?
8 कर दीजिए, 8 को मैं यहीं पे।
7th May, first sitting of the court. You come. If you don't come, stay at home.
Milord we will be able to Milord from Milord online Milord will be able
What? Either you choose this or choose this. You can't sail on two boats at the same time. That is our principle.
State will
Either you choose Meghalaya or you choose Guwahati or you choose Delhi. We were used to this. Either you go and appear before the Supreme Court or you appear before the High Court. You can't have your legs in both courts.
no, both can't be Milord both can't be Milord I do understand
This has happened with the COVID, onset of COVID, online and all that nonsense.
yeah, then who will come then 7th we are not here 7th Milord
Please choose any date which is not very far away.
5th है हम लोग।
हाँ 6th पर रख लो 6th पर रख लो 6th whether it will be possible Milord 6th
All right. All right, 6th May
6th
at the first sitting of the court.
all right much obliged
Two requests. My Lord, may record that a decision required from both sides. be presented.
Yes, we will say that. We direct advocates on record for both the parties, along with their respective clients, to sit in a conference, physical or online. Once or more than once, but ending before 30th April, to explore whether a settled amount as interest can be paid to the appellant. Full stop. We make it clear that more so in the case of the respondent, that only a person having the power to take an independent decision in the matter. Should participate in the meeting, full stop. In case that is not possible, the officer participating in the meeting should have access during the meeting to the person empowered to take an independent decision, so that the settlement process can be fruitfully undergone. Full stop. If the settlement process fails, then we shall have to deliver our judgment on the merits of the matter. Paragraph. Our observations above are strictly without prejudice to the rights and contentions of the party regarding the claim to interest. All right?
One last thing, my lord, sir. Pre-pendential interest, my lord, we just say pre-suit and pendential interest.
And that
All right, all right.
that may be included, my lord, because that was the expression used in the.
Mr. Agarwal, please try. So that,
My lord, before entering into this matter, my lord, I discussed this matter because my friend has already said, my lord, there was an earlier discussion on that. It was not possible. I thought that matter can be settled out of court or not.
yes. Because both ways there is equity, so that we can do some justice by settlement. All right?
Item number 1.
Please, Lordship. We have served a notice to the private respondent and the service report is still awaiting.
Still awaited.
May I please, Your Lordship? I'm appearing on behalf of respondents number 4, 5, and 6.
Oh, yes, they have received.
Okay.
Private respondent.
I'll file my affidavit, Your Lordship.
What is this appeal about?
This is regarding the Nokma slip, my lord. Nokma Akung. So what happened is because their allegation before that we have challenged the executive member, Iceland Revenue, has passed an order in the favor of the private respondent, allowing them to register as a Nokma.
Where is the impugned order?
The impugned order, Your Lordship, that is in the page 147. Is in the following page 47 till 155.
Where is the order? Page?
Page 147 of the read appeal. This in broad.
There is no merit in this appeal.
Your Lordship, what
You
happened?
have not even disclosed your locus, paragraph 8 of the judgment.
Your Lordship, what happened is actually only because the petitioner hearing has not filed the regional affidavit. Only on the ground that actually the basic is the main contention of the petitioner, the appellant hearing is that actually there were three complainants. Three complainant was filed against the private respondent, against the registration of the private respondent for allowing the Nokma, and then 2% actually they have withdrawn from the application, and on the basis of that only they are saying that since the person who filed the objection have withdrawn, only on the basis of that only this matter has been decided. Otherwise, my lord, there is a lot of judgment, Your Lordship. I will place the judgment, Your Lordship. What happened in the case of Dorisam, actually when
You cannot find any fresh pleadings in the appeal. So how will you establish your
Lordship, otherwise, my lord, I may be given an opportunity to file and rejoin the affidavit before the single. Otherwise, here only on the ground that there is only thing is that I am the in the Akun Nokma. Very important thing is that while deciding the Akun case, Your Lordship, the Nokma case, there's a headman, Your Lordship, they have to consider that that's an important clan chief of the clans, and all the Mahari, they are the main important people who will decide for appointment of lawpership, Your
So
Lordship.
you did not file a rejoinder disclosing those entitlements.
Your Lordship,
Now, what will you do in appeal?
Your Lordship, for the interest of justice, but I have make in my statement, I have make it a ground only because yes, of course, that is some discrepancy in by not filing there. Otherwise, I should have explained. But actually, Your Lordship, the appellant herein, he is the main chief plan of the that particular Akhung, Your Lordship. So in that Akhung, Your Lordship, even in the case of Doris Sama also, where the Akhung is decided, there should be three principles should be happen follow. One is framing of issues, another is taking on evidence, that is the examination of the document. Those three things were not there. And second, Your Lordship.
Yes, please take it up. We formally admit the appeal as all the respondents are represented. We propose to hear it out today, dispensing with all formalities. Paragraph. We find from the impugned judgment and order dated 23rd April 2024 that the writ was dismissed entirely on the ground that the appellant writ petitioner was not even able to establish his locus standi in court to maintain the writ or even to specify the reliefs he wanted. Full stop. He did not file any, she did not even file any rejoinder.
Not she, my lord, it's a he actually. And then this actually the petitioner before the single bench, he has already expired, Your Lordship. Now we have filed the substitution application, then this court has allowed. Now the original writ petitioner before the single bench already expired.
Original. He died after filing the appeal or before filing the appeal?
Before filing appeal, then we have filed an application to substitute. We filed an application to for leave application. Then after that we filed the.
Then you put out appellant everywhere, you see the original writ petitioner. Did not even file a rejoinder to the affidavit in opposition filed by the respondents in the writ. Which resulted in admission of the averments or allegations made in the affidavit. Paragraph. Now, learned senior advocate appearing for the appellant prays for an opportunity to file the rejoinder affidavit to establish the right of the original writ petitioner. He says that if such an opportunity is granted, the locus standi of the original writ petitioner. Would be established together with his rights. And in the beginning you write, the appellant is the heir and legal representative of the original writ petitioner. Who died before filing of the appeal, but after pronouncement of the impugned judgment.
Yes.
Huh?
Yes. After pronouncement of the judgment of the single bench.
Okay. Paragraph. Before the appellate court, such a prayer cannot be entertained. Paragraph. However, we dispose of this appeal by giving liberty to the appellant to take out a review or any other appropriate application before the learned single judge. For review or modification, no, for review of the impugned judgment and order, comma, keeping all rights and contentions with regard to maintainability of the application open. Try your luck.
What's your lordship?
Number 2.
May it please your lordship. Your lordship, on behalf of the National Highway Authorities, my lord, I have filed a small affidavit. My lord, we have brought a status report into record, my lord, and we are praying for grant of another 2 months' time to complete the remaining work, my lord. The repairing of the National Highway 6, starting from Joy to Ratachara, my lord.
Shall submit, my lord. Shall submit, my lord. The reports I have received, but apart from this report, my lord, there are areas, my lord, where the big bottles are still lying, my lord. In fact, I have the photographs. I've already forwarded to the council and the project director.
Potholes and all that.
Yes, they are there, my lord. Bottles are still there, my lord.
We are addressing to that, my lord. We are attending, and we expect that by another 2 or 3 months, my lord, we'll be able to address this, because in certain stretch, my lord, the road has been badly damaged and it needs concrete structure to be built on that, my lord. So,
Yes, my lord, temporarily, if those portals can be, my lord, filled.
we are doing the overall strengthening of the road itself, my lord. So it's not a temporary work. We are trying to attend to it on a sincere basis, my lord. If my lord will kindly grant us another 2 months or 3 months, my lord, then I believe we can show significant progress, and if possible, we would like to complete the work and say that the road is completely pothole free and totally constructed, my
The
lord.
photographs and the my lord, the location, I've already forwarded to the council and the project director, my lord.
Because the traffic flow cannot be completely stopped, my lord, and sometimes the intermittent rain also is damaging the work, my lord. We are trying our level best, so I'm praying for some more time, my lord.
Please take down. This writ relates to the strengthening and improvement of the Jovai-Rathachera Project Road of National Highways 6 bracket NH6 of about 102.255 kilometers in length. Paragraph further to our order dated 24th February 2025. The Project Director, National Highways Authority of India, PIU Shillong, after National Authority bracket NHAI, PIU Shillong, has filed an affidavit dated 11th April 2025 together with a status report. According to the status report, this strengthening and improvement work commenced on 22nd March 2024. By NHAI. Full stop. It is entrusted to two contractors, Purvanchal Buildtech Private Limited in respect of 51 kilometers, bracket Jawai to Vayajer, and Thor Construction Company in respect of 51.255 kilometers from Vayajer to Ratachera. This status report gives a detailed description of the work being carried out, accompanied by photographs. Full stop. In the first sector of 51 kilometers, 67% of the work is complete, and in the second sector, 73% is complete. Paragraph, the report mentions some impediments also in the progress of the work, like heavy flow of traffic. But nevertheless, it recognizes the cooperation of the district administration in regulating traffic. Paragraph, Mr. Sengupta appearing for the authority submits that if further 2 months were given to his client, the entire improvement and strengthening work would be completed. Next, learned amicus curiae points out that the defects points out that the problems in the highway, like
Umpiang area, my lord. Umpiang forest gate, my lord.
please take down that Umiang forest area,
And Dona. And I've already forwarded the photographs also.
like large potholes, exposed rods from small bridges, etc., as indicated in our order dated 24th February 2025, have not been addressed. Mr. Sengupta assures the court that in this 2 months' time, the work would be over and the problems and the said problems redressed. Paragraph. Overall, we are satisfied with the progress made by NHA. We adjourn this public interest litigation till 18 June with the expectation that the respondent authority would be in a position to file a completion report.
We'll make all attempts, my lord.
Why now make all attempts? Just asking for 2 months' time.
Yes, my lord, but subject to good weather also, my lord, and it's other factors. So
We are saying we expect
yes, my lord.
completion. That's
Number 3.
These are not hearing matters. 1 minute. We are keeping these matters on 22nd,
On 22nd, Your Lordship.
Monday. 21st is a holiday.
Lordship, if Lordship is pleased to have on 23rd, Your Lordship.
23rd,
Lordship.
already. 3, 4, 5.
No, Your Lordship, 3 is a separate appeal, Your Lordship.
Maybe.
Lordship.
This appeal is adjourned till 23rd.
Third, Your Lordship.
Similar order in 4 and 5. Okay, 4 to 7. Who's appealing in 4 to 7?
I'm appearing only in item number 3, Your Lordship.
4 to 7 Tuesday, the time will not permit today.
May it please, Your Lordship, Lordship, in item number 47, Your Lordship, we were required to file an informal paper book, Your Lordship. We were required to file an informal paper book, Your Lordship.
You have not filed.
Not filed, Your Lordship. Lordship, 2 weeks' time may be granted, Your Lordship, to file a...
When the order was passed?
Your Lordship, it was passed on 24th March, Your Lordship.
Then,
Lordship, actually, there are 4 matters.
Mr. Paul,
Paper book would be required, my lord, sir.
all right, then
My lords had condoned the delay and my lords directed formal listing of the appeals.
the delay also,
There was a delay, my lords, that's been condoned.
that has been condoned.
Condoned.
We have admitted the appeal.
Lordship,
Must have.
My lord.
All right. Then 4 to 7, one paper book will do, or for each.
One paper book should be enough, my lords. The core issue remains the same, my lords.
All right. Four, 5, 6, 7. All the appeals will be heard collectively. Time to file a paper book covering all the appeals is extended till 14, 30th, till 2nd May. List these appeals on 7th May.
7th.
I do oblige, Lordship.